Hong Kong Stock Exchange Directors Training. Responsibilities of directors of companies listed on the main board of the Hong Kong Stock Exchange. 22. Market Misconduct. The SFO sets out 6 types of market misconduct, which are prohibited in relation to shares listed on the exchange. Market misconduct includes insider dealing, false trading, price rigging, disclosure of information about prohibited transactions, stock market manipulation, and disclosure of false or misleading information inducing transactions. 1. False trading, sections 274 and 295 of the SFO. False trading takes place when a person 1. Intentionally or recklessly engages in conduct which creates a false or misleading appearance. A. Of active trading in securities or future contracts traded on an exchange or through an authorized automated trading service ATS in Hong Kong, or B. With respect to the market for or the price of such securities or futures contracts. 2. Engages in similar conduct similar to 1 above in Hong Kong, which has a similar effect on securities or futures contracts traded to an overseas market. 3. Is involved in 1 or more transactions with the intention that, or being reckless as to whether, they create or maintain an artificial price for securities or futures contracts traded on an exchange or through the ATS in Hong Kong, or futures contracts traded on an exchange or through an authorized automated trading service in Hong Kong. Or 4. Engages in similar to 3 above in Hong Kong, which has a similar effect on securities or futures contracts traded on an overseas market. A person who engages in an on-market wash sale or matched order is presumed to have committed false trading. A wash sale is a trade in which a person buys or sells securities without there being a change in beneficial ownership. A matched order is where a person offers to buy or sell securities at a price that is substantially the same as that at which he or an associate has made or proposes to make an offer to sell or buy substantially the same number of such securities. 2. Price rigging, sections 275 and 296 of the SFO. Price rigging occurs when a person engages in 1. A wash sale of securities, which maintains, increases, reduces, stabilizes, or causes fluctuations in the price of securities traded on an exchange or through an authorized automated trading service in Hong Kong. Or 2. Any fictitious or artificial transaction or device with the intention that, or being reckless as to whether, it maintains, increases, reduces, stabilizes, or causes fluctuations in the price of securities or futures contracts traded on the exchange or through an authorized automated trading service in Hong Kong. The same conduct by a person in Hong Kong which affects securities or futures contracts traded on an overseas market will also constitute price rigging if such conduct is unlawful in the country in which the relevant market is situated. 3. Stock market manipulation, sections 278 to 299 of the SFO. These provisions relate only to transactions in securities. Stock market manipulation occurs when a person in Hong Kong or elsewhere engages directly or indirectly in 2 or more transactions in the securities of a company that by themselves or in conjunction with any other transaction increase, reduce, maintain or stabilize the price of any securities traded on an exchange or through an authorized automated trading system in Hong Kong, or are likely to do so with the intention of inducing another person to buy or subscribe for or to refrain from selling securities issued by that corporation or a related corporation. The same conduct by a person in Hong Kong which affects securities traded on an overseas market will also amount to stock market manipulation if the same conduct is unlawful in the relevant country. 4. Disclosure of information about prohibited transactions under section 276 and 297 of the SFO. Disclosure of information about prohibited transactions occurs when a person in Hong Kong or elsewhere discloses or disseminates or authorizes or is concerned in the disclosure or dissemination of information about the effect or a prohibited transaction, being a transaction which contravenes the provisions of Part 8 and Part 9 of the SFO on the price of securities or the price for dealing in future contracts traded on a Hong Kong market if the person or an associate of his A. participates in the prohibited transaction, B. or benefits or expects to benefit directly or indirectly from the disclosure, circulation or dissemination of the information. 5. Disclosure of false or misleading information inducing transactions, sections 277 and 298 of the SFO. This form of market misconduct concerns the disclosure of false or misleading information about securities or futures contracts that is likely to induce investment decisions or have a material price effect. A person will have engaged in market misconduct if he discloses or is involved in the disclosure of 1. Information likely to induce others to enter into transactions or to affect the price of securities or futures contracts that is false or misleading in a material fact or through the omission of a material fact. And 2. He knows or is reckless, or for the civil market misconduct only, negligent as to whether the information is false or misleading in a material fact or through the omission of a material fact. Negligence will not suffice to establish criminal liability. 6. Dual civil and criminal regimes. The 6 forms of market misconduct may either be prosecuted as a criminal offence under Part 14 SFO or made the subject of civil proceedings before the Market Misconduct Tribunal. 7. Criminal penalties. The maximum criminal sanction is 10 years imprisonment and or a fine of up to 10 million Hong Kong dollars. The court may also impose disqualification, cold shoulder, and disciplinary referral orders. Failure to comply with a disqualification or cold shoulder order is an offence liable to a maximum fine of 1 million Hong Kong dollars and up to 2 years imprisonment. 8. No double jeopardy. A person will not be subject to the double jeopardy of both civil proceedings under Part 13 and civil proceedings under Part 14 for the same conduct. The SFO provisions that a person who has been subject to criminal proceedings under Part 14 may not be subject to a market misconduct tribunal proceedings if those proceedings are still pending or if no further criminal prosecution could be brought against that person, again under Part 14 in respect of the same conduct and vice versa, Section 283 and 307 SFO. 9. Proceedings of the Market Misconduct Tribunal. The Market Misconduct Tribunal may identify a person as having engaged in market misconduct if 1. He has perpetrated any market misconduct, 2. The market misconduct was perpetrated by a corporation of which he is an officer with his consent or connivance. 3. Another person engaged in market misconduct, and he assisted or connived with that person in the perpetration of the market misconduct, knowing that such conduct constitutes or might constitute market misconduct. 10. Orders of the Market Misconduct Tribunal. At the end of any proceedings, the Market Misconduct Tribunal may impose the following sanctions. A. Disqualification order, that a person shall not, without the leave of the court of first instance, be or continue to be a director, liquidator, or receiver or manager of the property or business of a listed corporation or any other specified corporation, or in any way, whether directly or indirectly, be concerned or take part in the management of a listed corporation or other specified corporation for up to 5 years. B. A cold shoulder order, that a person shall not, without the leave of the court of first instance in Hong Kong, directly or indirectly, deal in any securities, futures contracts, or leveraged foreign exchange contract, or an interest in any of them or a collective investment scheme for up to 5 years. C. A ceased and desist order, that the person must not again engage in any specified form of market misconduct. D. A disgorgement order, that the person pay to the government an amount up to the amount of any profit gained or loss avoided as a result of the market misconduct. E. Government costs order, that the person pay to the government its costs and expenses in relation to the proceedings and any investigation. F. SFC cost order, that the person pay the SFC's costs and expenses in relation to any investigation. And G. Disciplinary referral order, that any body which may take disciplinary action against the person as one of its members be recommended to take such action against him. 11. Civil liability, private right of action. The SFO creates a private right of civil action in favor of anyone who has suffered financial loss as a result of market misconduct or any offence under Part 14 to seek damages from the person who committed the market misconduct or Part 14 offence. The perpetrator is liable to pay damages unless it is fair, just and reasonable that he should not. Section 281 and 305 SFO. A person will be taken to have committed market misconduct if 1. He has perpetrated any market misconduct. 2. The market misconduct was perpetrated by a corporation of which he is an officer with his consent or connivance. Or 3. Any other person committed market misconduct and he assisted or connived with that person in the perpetration of the market misconduct, knowing that such conduct constitutes or might constitute market misconduct. 12. Liability of officers. Section 279 of the SFO imposes a duty on all officers of a corporation to take reasonable measures to ensure that proper safeguards exist to prevent the corporation from acting in a way which would result in the corporation perpetrating any market misconduct. The duty applies to all forms of market misconduct and not just insider dealing. The definition of an officer of a corporation includes a director, including a shadow director, and any person occupying the position of a director, manager, or secretary of, or any other person involved in the management of the corporation. The last category, i.e., any other person involved in management, could in principle catch supervisors and anyone else with management responsibilities. Under Section 258, where a corporation has been identified as having been engaged in market misconduct, and the market misconduct is directly or indirectly attributable to a breach by any person as an officer of the corporation of the duty imposed on him by Section 279, the Market Misconduct Tribunal may make one or more of the orders detailed above in respect of that person, even if that person has not been identified as having engaged in market misconduct himself. However, a breach of the Section 279 duty will not expose a person to civil suits by third parties unless he has been identified as having engaged in market misconduct. 13. Civil liability of officers. As described above, the SFO clearly provides that anyone who suffers financial loss as a result of market misconduct or a Part 14 offence has a right of civil action to seek compensation. As noted above, an officer of a corporation which perpetrated market misconduct is taken to have committed market misconduct himself if the corporation perpetrated the misconduct with his consent or connivance. 14. Criminal liability of officers. Under Section 390 of the SFO, where it is proved that an offence committed under Part 14 was aided, abetted, counselled, procured, or induced by, or committed with the consent or connivance of, or attributable to the recklessness of, any officer of the corporation, or any person purporting to act in any such capacity, that person, as well as the corporation, is guilty of the offence and liable to be punished accordingly.